Today, we are speaking with Garnet Henderson. She is the Senior Multiplatform Reporter at Rewire News Group. Prior to joining RNG, she spent a decade as a freelancer reporting on the intersections of health and culture with a particular focus on reproductive health and abortion access. Her work has been published in Cosmopolitan, ELLE, Scientific American, Marie Claire, Vice, Guardian US, Wired, Glamour, Quartz, The Atlantic, and other publications. That is impressive. Her guide to abortion care in the US was part of the Tonic Guide to Healthcare, which won a 2018 Deadline Club Award. In 2020, Garnet created Access, a podcast about abortion, which she hosts and produces as a solo project. In 2022, she was one of the inaugural grantees of the International Women's Media Foundation's Reproductive Rights Reporting Fund for a project that was co-published in The Nation and on Access. Garnet was born and raised in Jackson, Wyoming, and has lived in New York City since 2009. It's quite an impressive resume. Am I missing anything?
I don't think so. Thank you so much for having me today.
Well, this is a really timely discussion. Like I said, we're monitoring very closely not only what's happening at the national level, but what's happening here at the legislature and even at our school boards and city councils. So with that, I'm just going to go ahead and hand it off to you, and feel free to share your screen. Like I said, I'll monitor the chat, and take it away, Garnet.
Thank you. Yeah, let me just share my screen here. And full screen that window. All right, so hopefully everyone can see my screen now. Okay, perfect. So yes, my name is Garnet Henderson. I am Rewire's Senior Multiplatform Reporter. I do a lot of coverage of access to abortion and contraception, but my beat is really broad and it includes all kinds of reproductive and sexual health care. And so I also do a lot of reporting on gender affirming care. So today I'm going to talk about this Supreme Court case, LW versus Skrmetti or US versus Skrmetti. It's the same case. They're joined together, so you might hear both names used to reference it. And I'm also going to open things up and talk a little bit more broadly about the likely future of trans health under Trump. So some background on this case. You'll also hear this law alternately referred to as Tennessee Senate Bill 1 or Public Chapter 1. It was signed into law in March of 2023, and it went into effect on July 1st of 2023. It banned the use of puberty blockers, hormones, and medical procedures that would enable a minor to identify with or live as a purported identity inconsistent with the minor's sex. That's a direct quote from the law. So it required existing gender affirming care regimens to be ended within about 9 months of the effective date of the law. And it also included a very explicit exception for treatments that are consistent with a child's birth sex. And that will become important when we get into talking about the litigation around this law. So this is a civil ban, it's not a criminal ban. So it includes a private right of action, meaning that a child's next of kin could bring a lawsuit against a doctor or other healthcare provider for providing them with gender affirming care. And then the state attorney general can also take action, and that could lead to fines of up to $25,000, as well as licensing sanctions from the state's medical board. And let me see if I just adjust. Is everyone still seeing my screen correctly? I hope so.
It's not full screen.
It's not full screen. Yeah,
okay,
we can
here.
see
Let
like
me
the
just
background of your
move.
desktop there. Yeah.
Great. Let me just full screen it again. Perfect. Okay, thank you. So this is a really helpful map from the Kaiser Family Foundation showing that currently 39% of trans youth between the ages of 13 and 17 are now living in a US state with a law or policy that limits their access to gender affirming care. So I wanted to just point out that this Tennessee ban that ultimately became a Supreme Court case is part of a much larger wave of these bans on gender affirming care that have gone into effect across the country. And this also only includes children who are between 13 and 17. So it doesn't even reflect the full number of kids who might want to access a gender affirming care service, such as puberty blockers in particular, and now can't access that in their state due to a ban. And then I just wanted to show this map as well, which shows the current effective status of these laws. So one has been permanently blocked in Arkansas. There's one in New Hampshire, as you can see up there in the top right corner of the map, that has been passed but is not yet in effect. And Montana's ban is temporarily blocked. So all the other states you see on this map as blue are states that have some kind of ban in effect on gender affirming care for young people. So I wanted to pull out just a few details from this law. I'm not going to go through every single section exhaustively. I don't think anybody wants to read all the text, but I just wanted to point out a few really relevant sections. So this section is from the findings section at the very beginning of the law. So if you haven't spent as much time staring at legislation as I have, there's usually a findings section up at the top, which is theoretically a statement of fact. Although I want to emphasize that the term fact here is relative. It is whatever lawmakers want to assert as fact. It does not mean that these things are necessarily objective facts. So this section says the legislature determines that medical procedures that alter a minor's hormonal balance, remove a minor's sex organs, or otherwise change a minor's physical appearance are harmful to a minor when these medical procedures are performed for the purpose of enabling a minor to identify with or live as a purported identity inconsistent with the minor's sex. So they're explicitly saying here that gender affirming care is only bad when it is provided to a transgender child. And I also want to point out in the second half of this section, it says these procedures can lead to the minor becoming irreversibly sterile. And that's just a really important point to note, because this is something that came up a lot during Supreme Court arguments. I'll talk about this a little bit more later, but it's actually not true. So for young prepubescent and pubescent children, the type of treatments we're talking about when we talk about gender affirming care are mostly two things. Puberty blockers, which can stop them from going through a puberty that is inconsistent with the gender they identify with. And then eventually, sometimes cross-sex hormones, usually when they're a little bit older. And it's actually a misconception that taking cross-sex hormones makes you irreversibly sterile, as this law says. In many cases, it actually does not lead to significant impacts on fertility at all. And it certainly doesn't lead to irreversible impacts in most cases. And this is important because, you know, ideologically, a lot of the people who oppose gender affirming care are coming from a conservative Christian, and I would say Christian nationalist perspective. They are pronatalists. They want people, specifically usually white Christian people, to reproduce. And that is one of their major reasons for opposing gender affirming care, is really that they claim that it can cause sterility, which is something they definitionally oppose. So here is some of the text of the law itself. It says a healthcare provider shall not knowingly perform or offer to perform a medical procedure if the procedure is for the purpose of, as I read earlier, enabling a minor to identify with or identify with a sex that's not the same as their sex at birth, treating gender dysphoria, and then it also includes down there in section 2B, a prohibition on telehealth, because a lot of providers in states where gender affirming care remains legal are providing that care to people in states where it is illegal. And then I just also wanted to show this section, which first of all shows that there is an explicit exception for care that is to treat a minor's congenital defect, precocious puberty, disease, or physical injury. So in other words, if we have a young cisgender girl who's going through precocious puberty, it's perfectly fine for her to take puberty blockers. But for a transgender girl, it is not. Conversely, say there's a young cisgender boy who is experiencing delayed puberty. It's fine for a doctor to prescribe him testosterone, right? To help him grow, to help his voice deepen, but it's not fine for a transgender boy. So that is very explicit in the law, and that's important because when we get to the Supreme Court, this is, at least some would argue, a sex discrimination case. And we can see here that there's a clear distinction drawn based on the child's birth sex. It's about whether or not the treatment they're being provided aligns with the sex that was observed at their birth. And then here's also the rule basically saying that any existing gender affirming care may be able to continue after the law is enacted, but it has to be wrapped up on or before March 31st, 2024. So that was about 9 months after this law took effect. So just a really brief timeline of the case. Again, this ban was signed by the governor in March of 2023. Very shortly thereafter, in April, the ACLU sued on behalf of the original plaintiffs. Those original plaintiffs are a transgender girl who's identified in the case as LW and her parents, 2 other families that are fully anonymous, they're unnamed, and 1 physician, 1 provider of gender affirming care. And very early on, the United States government intervened, making very similar arguments to the ones the ACLU made in the case, namely that this is a clear example of discrimination based on sex. So then in June 2023, a federal district court blocked this ban just days before it was set to go into effect. But shortly after that, the Sixth Circuit Court of Appeals did allow it to take effect. And then there are a few steps on the timeline that I've omitted just to not get too bogged down in it. But basically, the Sixth Circuit made its final ruling in the case in September of 2023. And very shortly thereafter, both the ACLU and the United States government asked the Supreme Court to take the case. And they did not make a decision on that until June 2024, when ultimately they did decide to make the case. This is something we've actually seen a lot, I will just note, in recent years, is that when these cases come up that involve major social issues, we've seen this, for example, with several abortion cases, the Supreme Court tends to conference on them for a long time. So you'll see it pop up on their agenda just constantly for discussion, but it takes them a while to take it on, and that's what happened in this case. But ultimately, they did take it at the very end of their 2024 June session, and the oral arguments took place in December of 2024. So there are a lot of arguments being made here, but just to summarize them briefly, the United States and the ACLU split their argument time. They kind of tag teamed this case. They both argued that gender affirming care is safe, it's evidence-based, and it's essential for the well-being of trans kids. In particular, they cited a lot of the really detrimental effects on mental health for kids who need gender affirming care and are not able to receive it. And then the most salient legal argument here is that this ban on gender affirming care in Tennessee violates the Equal Protection Clause of the 14th Amendment by creating a sex-based classification. And when it comes to judicial interpretations of the 14th Amendment's Equal Protection Clause, there's this idea that certain groups of people are what are called suspect classes. So basically, if it's a group of people that has been discriminated against systemically in the past, then any law that singles out that same group of people deserves a higher level of scrutiny from the courts. So both the United States and the ACLU were making this argument that because sex discrimination, because sex is one of these suspect classes, then inherently this law deserves a really high degree of scrutiny. It's very clear that the liberal justices on the court agreed with them there, not surprisingly. But Tennessee, on the other hand, was arguing that this law does not discriminate based on sex or draw any kind of distinction based on sex, only draws a distinction based on age. And we can see very clearly that that is not true. As I showed you, treatments that are perfectly legal for a cisgender child are illegal for a transgender child under this law. And the deciding factor there is what the child's sex was at birth. There really couldn't be a more explicit sex-based classification than that. The Tennessee Solicitor General also spent a lot of time talking about this idea that a trans child might later regret gender-affirming care. He mentioned that potential loss of fertility many, many times. And a lot of the conservative justices, again, not surprisingly, were very invested in that point. And Tennessee is also citing a few international examples. One is a report called the Cass Review from the UK, and another is some recent Swedish government guidelines. And the Cass Review in particular got a lot of play. Justice Alito specifically brought it up many, many, many times. So I did just want to talk briefly about the Cass Review in case anyone is not familiar with it. So this is a report that was commissioned by the National Health Service in the UK. And its ultimate conclusion was that the benefits of gender-affirming care have not yet been demonstrated to outweigh its potential risks in all cases. But this report was very widely criticized for a lot of reasons. Number one being its highly selective use of data. There are a lot of recent high-quality studies that were just completely omitted from this review. And there's a lot of anti-trans bias at the very foundation of the entire effort. So Dr. Hilary Cass, who led this team and for whom the review was named, was specifically chosen because of her lack of experience in providing gender-affirming care as a physician. And the original terms of reference that were handed down from the UK government to guide this review intentionally excluded, and this is a direct quote from those terms, subject matter experts or people with lived experience of gender services from the assurance group that guided the review process. A good resource on this, if you'd like to learn more, is a paper from the Yale Law School's Integrity Project that's called an evidence-based critique of the Cass Review. So if you want to learn more, I would really recommend taking a peek at that. And I also want to point out, and both the United States and the ACLU pointed out in their oral arguments in this case, that these guidelines, both in the UK and in Sweden, instituted new limits on gender-affirming care, but did not ban gender-affirming care outright. So these examples were being pointed to constantly throughout arguments, but it's really different from what we're talking about here, where we're seeing states just immediately enact these blanket bans on gender-affirming care for young people. So again, the risk of regret was a major theme. It got a lot of play among the conservative justices. There are a lot of quotes I could have pulled out here, but I thought this one from Brett Kavanaugh kind of summarized the whole conversation. So he said, if the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. And so there are risks both ways in here. It's a difficult judgment call as a matter of policy. So ACLU attorney Chase Strangio happens to be the first openly transgender person to have argued a case in front of the Supreme Court. And he was really well prepared to answer a lot of these questions, speaking from a place of both professional and personal expertise. And so he pointed out that a lot of these claims about regret actually come from very old and poorly designed studies of very young children. Prepubescent children. And when we talk about gender-affirming care, medical transition is not being offered to prepubescent children. So the types of gender transition a child might be supported in experimenting with at that age are social transition, so like using a different name or different pronouns. Medical transition care is really not offered to children until they reach the age of puberty. And so what Chase Strangio pointed out here is that the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low as 1%. And I think the ACLU's brief in this case also does a really nice job of laying out the fact that, contrary to this idea that was coming up a lot among the conservative justices, that providing a child with gender-affirming care is sort of rushing to confirm a rash decision that they might regret later, what it's actually doing is to help stop or slow the clock, to ensure that that child doesn't have to suffer by going through a puberty that doesn't align with the gender they identify with. And it gives them more time to make choices and to really arrive at an understanding of themselves and their identity. So actually the ACLU's brief lays out the story of their original plaintiff, in this case, the person identified as LW. And it explains that she initially, when she was younger, identified as non-binary and used they, them pronouns for a while. And then as she got older and she reached that age of puberty, she really came into an identity as a girl. And what puberty blockers allowed her to do was to have time to figure that out and make that decision. So the truth is very much the opposite of the way that conservatives want to paint this care. But maybe there is regret among about 1% of people, right? And so what do we do with that 1%? Well, that reminded me of a concept that I have learned about through my work on abortion rights that's called the dignity of risk. So I wrote about this. I wrote an analysis called Gender Affirming Care and the Dignity of Risk. And the concept of dignity of risk comes from the disability rights movement. So it was an activist named Robert Persky who first coined this term in a paper he wrote in 1972. And he said that overprotection undermines a person's individuality and growth potential, smothers them emotionally, and prevents them from experiencing the normal taking risks in life, which is necessary for normal human growth and development. And since that time, this has become a really important concept in bioethics. It's been applied in a lot of other areas, one of them being adolescent development, which obviously is very relevant here, right? So a lot of experts would argue that rather than shielding an adolescent from any and all risk, the healthier approach is to allow them to take age-appropriate, supported risks in a safe environment and learn from them. Right? This is how we develop, it's how we grow, and in fact, it's how we develop our capacity to make decisions. If you're never given an opportunity to make a decision for yourself, you're not appropriately developing that capacity. So many experts would argue that dignity of risk and age-appropriate risk is really important for adolescent and child development. And another area that this has been applied is in abortion rights. And I want to talk about that a bit just because there is so much overlap between attacks on abortion rights and access to gender affirming care. The same people and groups are opposed to both abortion and gender affirming care. And I think it's really worthwhile understanding why and understanding how a lot of the same strategies and language are being used to attack these two forms of healthcare. So I made an episode of my podcast Access back in 2021 about the myth of abortion regret, introducing this idea of dignity of risk. So I spoke with a bioethicist named Katie Watson, who is an expert in abortion rights, and she wrote a great commentary about the dignity of risk, applying this framework to abortion rights for the Journal of the American Medical Association several years back. And what she said to me is that failure is part of being an autonomous adult. That's how you learn. That's how you develop resilience, which I think is really beautiful. And I also talked to an epidemiologist named Corinne Rocca, who was one of the investigators of the Turnaway study. So some people on this call might be familiar with the Turnaway study. This is an amazing, really longitudinal study that has now inspired work in a number of other countries, where this team at the University of California, San Francisco, followed a group of women who wanted abortions and were able to get their wanted abortions, and then a group of women who wanted abortions but were denied that abortion care. And they followed them over a very long period of time to track their experiences and compare the outcomes between those two groups. And Corinne authored a paper using some of this turnaway study data, specifically looking at this myth of regret. And what they found in the turnaway study is that 5 years after an abortion, 95% of people who'd had an abortion said that it was the right decision for them and that they didn't feel regret. And even among that 5% of people who said they felt the feeling of regret, the vast majority of people still did not think that having an abortion was the wrong decision. So what Corinne said to me is, I think it's really important to distinguish decision rightness or decisional regret from having negative emotions or even the emotion of regret. And so I spoke with two women in that episode who both told stories that kind of align with that idea, where they feel regret and sadness around their abortions, not because they wish they hadn't made the decision, but because they wish they hadn't been faced with the circumstances that required them to make the decision. Regret is very complicated. It's not actually something that can be flattened into this kind of black and white thing. And again, it's also not necessarily good policy to try and protect people from regret. So I did just want to show some rates of regret for other common medical procedures. Elective plastic surgery that's not related to gender affirming care has rates of regret up to 47%. I even saw one study that actually put it as high as 60%. Bariatric surgery, weight loss surgery, has a regret rate of about 20%, and knee replacement has a regret rate of about 10%, which is actually down. It used to be as high as 30 or 40% about a decade ago. And these are not procedures that we're trying to legislate to protect people from this regret, including, I would add, young people. A lot of cisgender girls, for example, get breast implants or other cosmetic surgery when they're still teenagers. And as long as they are transgender, as long as they are not transgender, excuse me, none of our lawmakers seem to have concerns about that at all. And same with bariatric surgery. Bariatric surgery is increasingly being recommended for children, and no one is trying to legislate to stop that. So as I said earlier, there is a tremendous amount of overlap between opposition to abortion access and opposition to gender affirming care. So I did just want to drill down on that a little bit. Common values among people and groups who oppose both of these things. Generally speaking, Christian nationalism is the big one. These are people who want to reinforce traditional, very binary gender roles and force a return to traditional, meaning Christian, conservative family structures. And a lot of common strategies are being used here, with abortion kind of being the leader. Abortion rights have been under attack in the United States for longer than the right to gender affirming care, simply because gender affirming care as it exists today is a bit newer as a form of medical care. I would say that attacks on abortion access and attacks on gender expression have absolutely been going on together forever in the United States. But in terms of the law, abortion is kind of ahead. And so we can look at that and deduce what next steps are probably going to be taken to try and restrict access to gender affirming care. So the number one strategy is mis and disinformation. Misinformation about people who have abortions, about the safety of abortion. And we see the same thing with gender affirming care, right? The groomer myth, the idea that queer and trans people are trying to somehow lure in or convert children. And all these myths I've already covered today, like that gender affirming care is dangerous, so many people regret it, etc. Violence and threats of violence against providers. A great way to reduce the availability of care is to make people afraid to provide it. And that's something we have seen for a long time with abortion and have seen increasingly over the last few years with gender affirming care. Religious or conscience refusals. So I'm going to talk about this more in a minute, but particularly under the Trump administration, we are certain to see an expansion of protections for healthcare workers who do not want to provide these types of care. And then finally, there are a lot of other just identical legal strategies in use, everything from outright bans to restrictions on the use of federal or state funding for care, and restrictions on private insurance coverage as well. So I just wanted to quickly show the map of abortion bans in the United States. One thing I like about this map from KFF is that you can see the red and orange states are the states that have either total abortion bans, near total bans, or early gestational limits on abortion. But what I like about this map is that it shows that actually almost every single state in the United States has some kind of ban on abortion, because bans or laws that ban abortion at or near viability are still bans on abortion. So the only states that have no restrictions on abortion are the dark blue ones, although that does not mean that abortion is necessarily fully accessible in those states either. So yeah, just taking a look at that, I think that unfortunately we can assume that the US map when it comes to policies on gender affirming care is probably going to look quite similar to this over the next couple of years. We'll see that most states have some kind of restriction, even if it's not an outright ban. So what's next for gender affirming care under the second Trump administration? Well, in this case, LW versus Skrmetti or US versus Skrmetti, shortly after Trump took office, well, earlier this month, you can see the date right there, it's February 7th, the US Department of Justice took the very unusual step of sending a letter to the Supreme Court basically saying, hey, the present administration would not have joined in this case because remember the ACLU filed the lawsuit first, and then the United States asked a court for permission to intervene and was granted that permission. So this letter basically says, hey, actually the current administration would not have intervened in this case, and we do not believe this Tennessee law is gender discrimination. We don't believe it violates the 14th Amendment. Now, this case has already been argued before the Supreme Court and submitted. So technically at this point, to put it in playground language, there are no takebacks. The United States argued what it argued back in December. It can't change that now. And either way, the ACLU and the original plaintiffs are still there, and they also got to put in their arguments. So it's unclear how or whether the Supreme Court is going to respond to that letter. Either way, we can probably expect a decision in Skrmetti case by June of this year and probably in June of this year, because what we know about the Supreme Court is that they love to drop these potentially controversial decisions at the very end of their term, right before they head out of town. Other abortion rights parallels that we are seeing are attacks on the use of federal funding for gender affirming care. So after Roe versus Wade was decided in 1973, the very first new abortion restrictions we ever saw were restrictions on federal funding for abortion. So first, there was a policy called the Helms Amendment that banned US foreign aid funds from paying for abortion care. And then there was a policy that probably more people are familiar with called the Hyde Amendment that banned the use of federal funds for abortion care here in the United States. Originally, this only affected Medicaid, but now it has been expanded to cover every type of government-paid health insurance, federal government-paid health insurance. So that's Medicare, Medicaid, the Child Health Insurance Program, the Indian Health Service, TRICARE, which is the insurance program for military members. It also affects people in the Peace Corps and people in federal prisons. So many people, myself included, have expected that this is probably going to be one of the first steps that Donald Trump would take to limit access to gender-affirming care, because during his presidential campaign, he promised a national ban on gender-affirming care for young people. And he said it would go very quickly. That's a quote. And whether or not that would go very quickly through Congress, probably it wouldn't. But again, we could safely assume that Trump was probably going to use his executive power to do what he could. And one of the easy ways to approach it is to use his executive power to ban the use of federal funds for gender-affirming care. However, these attacks actually began before Trump even took office. So in the National Defense Authorization Act of 2025, which was actually passed and signed into law in late 2024, while Joe Biden was still president, there was included in that bill, which is one of the annual spending bills that gets passed every single year, included in the NDAA for 2025 is a ban on coverage through TRICARE, which is that program of insurance for active duty military members, a ban on TRICARE coverage of gender-affirming care for children. So that means the children of active duty military members. This was enacted before Trump took office, as I said, with quite weak Democratic opposition. I think that's very important to note because Democrats had a chance to make more of a stand on this, and they did not take it. Joe Biden did issue a statement when he signed the NDAA, basically saying that he opposed that portion, but he signed it anyway. And then, of course, within the first week of Trump's presidency, he took the expected move of issuing an executive order barring federal funds for gender-affirming care, but he actually took it one step farther, because what that executive order says is that any facilities receiving federal funds cannot provide any gender-affirming care, which is a broader ban. Because pretty much every healthcare facility in the United States receives federal funding in some way, usually through Medicare and Medicaid, also through the subsidized health plans that people get on the Affordable Care Act marketplaces. So we saw, unfortunately, a lot of hospitals comply in advance with this, even though it didn't take effect immediately, and it was pretty much guaranteed there were going to be legal challenges to that executive order. I live in New York. We had two major hospitals here in New York City cancel appointments for gender-affirming care for youth, even though our state attorney general told them that they couldn't do that because it violates New York state law. They did it anyway. But that executive order was blocked by one federal judge yesterday, just last night, and there's actually a hearing in a different federal court about it today. So I expect that there's going to be a lot of back and forth on this, but frankly, it really is going to come down to individual hospitals and facilities and how conservative, and I mean legally conservative, they decide to be in their approach to these executive orders. Unfortunately, I expect that many hospitals will continue to comply even with the ban blocked, because again, that's something we have seen a lot in the abortion access realm, is a lot of complying in advance or over complying with restrictive laws. And I think it's also kind of up to state attorney generals in states where gender affirming care is legal and protected to decide how aggressive they're going to be in trying to push hospitals in their states not to comply. There are lots of ifs in this situation, basically. And unfortunately, now that we have seen this happen at the federal level, this is likely to inspire a lot of copycat state bans. Again, this is something that happened with abortion access, where once the Hyde Amendment was in place on the federal level, tons of states decided to also ban public funding from being used to pay for abortion care, which again affects Medicaid, because Medicaid is jointly funded by states and the federal government. Usually that also affects health coverage for state employees. We've already seen Florida do this, ban Medicaid from covering gender affirming care. That law is being challenged, but it is in effect. So we could see that spread to more states. And then, as we have seen with abortion care, we could also see either bans on private insurance coverage of gender affirming care, or we could also just see private health insurers back off gender affirming care simply because they don't feel like paying for it. We all know that insurers would like to pay for less rather than more. And so a lot of times when something becomes controversial like this, they'll just stop covering it just because they can. It just gives them an easy out. And, you know, a lot of this stuff comes straight from Project 2025. So just the top lines of Project 2025 and what it says about gender affirming care. It says that the Centers for Medicare and Medicaid Services should label gender affirming care as not evidence-based. Most insurers decide what they're going to cover and how much they're going to pay for it based on what the Centers for Medicare and Medicaid Services say about that care. So again, this is a way of encouraging private insurers to just stop that coverage. Project 2025 also said we should ban federal funds from being used for gender affirming care. It says we should change the enforcement of Section 1557 of the Affordable Care Act. 1557 is the anti-discrimination protection in the Affordable Care Act. Under the first Trump administration, we saw the rule for enforcing this provision basically be transformed into a protection, as I mentioned earlier, for healthcare providers who want to refuse certain forms of care based on their religious or other moral views. So we saw Section 1557 basically change from an anti-discrimination protection into a protection for healthcare workers so that they can discriminate against queer and trans people, HIV positive people, and people who may seek or have sought at some point abortion care. Project 2025 also says we should require parental permission for students to change their names and pronouns at school, bar trans people from military service, another thing Trump has already tried via executive order, reverse efforts to expand the Title IX protections that the Biden administration undertook, and officially define sex only as a person's biological sex recognized at birth, and to put broad limits on speech about gender and gender identity, basically ensuring that we never even talk about the fact that some people may not identify with the gender they were assigned at birth. So I just wanted to share these quotes from some people I interviewed for a story I wrote about what's at stake here. And the potential impacts of bans and restrictions on care. It very likely means that we will see people start to administer their own gender affirming care. And there is a history of that within the trans community, since historically and presently, trans people tend to have worse access to medical care overall. But obviously there are risks that come along with that. And to a lot of people, it also feels like we had been experiencing a real trajectory toward progress, and that progress is now being clawed back. So I'm sorry to end on that kind of down note, but that is everything that I wanted to say, and I'm happy to stop sharing my screen and take any questions that anybody had.
Well, this is officially called our Secular Speaker Series, but it's been dubbed Rage Friday, and today was particularly rage-inducing. So, but we're used to it. We're not going to get mad at you or anything like that.
Good.
Yeah, if you want to stop sharing so we can see your face, like so we can see you larger, that would be great. I do have the first question was about, can we get the map? So I don't know if you're going to be sharing this presentation in a PDF format or something like that so people could access it, or if that map is somewhere where you can point people in that direction so that they can find it. Oh, wait, you're muted though, Garnet.
Okay, I'm back. Yes, I'm happy to drop the link to the map in the chat.
Oh, perfect. Great.
It's in my notes. So yeah, I'll do that in 1 second.
And then while you're doing that, another question came in asking, like, what organization is the major funding source for all of these bills, this flurry of bills?
Mhm. There are a couple, I would say. So the Heritage Foundation, which headed up the whole Project 2025 effort, has an advisory board that is basically like a who's who list of all of the most powerful far-right groups in the US. And I think when you look on there, you can see that it's actually, unfortunately, I hate to say this, but a very large and well-coordinated group of organizations. But in terms of where the model legislation is coming from, a lot of it is probably coming from ALEC, which is a huge producer of model legislation for all kinds of conservative causes. But frankly, like there is a whole and very well coordinated group behind this group of groups.
And it's a web, I've seen those graphics before, where with like Heritage Foundation in the center, and then, you've got ADF and you've got TPUSA and you've got like Moms for Liberty and all these horrible groups. And they've, fine-tuned this well-oiled machine for the last 40, 50 years with their eye on the prize. And this is what we talk about every Friday. And we just don't have that on our side because we welcome a lot of different ideas. Progressive folks tend to want to hear from more people than just those that are in power. But for so many of these people, their whole identity is first, Christian nationalism, they give their power immediately to God because they're told their whole entire lives that there's this, creepy old guy in the sky watching their every move, and he's going to judge them for everything that they do. And then they have to submit their power to their fathers and then their husbands. It's just, it's easy for them to implement this stuff. But anyway, I digress because I'm trying to find the question that came from Philip. And I remember the gist of it. It was something about, okay, wait, nope, that's not it. There's a lot of commentary in here for sure. But Philip was basically asking, because you mentioned the CAS study and that it's flawed. And he was basically asking something about like how many peer-reviewed journal studies have been done that aren't flawed. Do you have any idea? Like, I don't know if you can answer that question, but you can give it a shot.
Yeah, sure. I mean, I definitely don't know the number off the top of my head, but a lot of them are cited both in the, so I know reading legal briefs is like not particularly pleasant, but the ACLU in the United States submitted a joint brief to the Supreme Court in this case that actually lays out super well a lot of the best evidence on gender affirming care that we have. And there's also, I mean, there are a couple of different professional organizations, but the major one in this area is called WPATH. So it's the World Professional Association for Transgender Health. They are a group that develops the recommendations for standard of care for gender affirming care and best practices. And so their website is also full of resources on the higher quality studies that we have. But I'll also say that this is actually an area where everyone agrees that we should have more and better research. But the reason we don't have it is because of systemic discrimination against trans people. So it's really ironic, right, to say like, we don't have enough evidence about this when the whole problem is the discrimination that we're seeing play out in these bans.
Mm-hmm. And there's a lot of talk too here about the intersectionality of all of this. And I read an article a few weeks ago about how Christian nationalists also rely heavily on the gender binary so that
Yes.
they can control women. And so it's very important for them to classify people into these very rigid, boxes of like what their gender identity or even their sexuality are.
Yeah, absolutely. And Pat just said in the chat, and now they're cutting back medical research funds. That's exactly right. And another one of Trump's, one of his many executive orders, right, is this ban on DEI. And so what that means specifically is that we're going to see research funds cut overall, yes, but also we're going to see zero federal research dollars go to, for example, investigating best practices in gender affirming care, because that's DEI, right? I mean, that's not what DEI means, but that's what they mean when they say, that's what the Trump administration means when it says DEI. And on the point about the gender binary, I'll also say that we have in a government role now, Elon Musk, who is part of this right-wing tech pro-natalist movement, right? And so I don't know that he's Christian, probably not. I doubt he's a religious man. But the thing is, a lot of these kind of like new Silicon Valley pro-natalists have a lot in common with Christian nationalists, because they all have this idea in reproduction overall. And when they say reproduction, they mean for white people only, although they don't usually say that part, right? You know, this interest in the traditional gender binary, forcing people into those roles and getting them to reproduce as much as possible.
What do you think is going to happen with regards to, like, I didn't read the article, but there was a headline about, you know, because Tim Walz, oh, we could have had him as vice president, but Tim Walz came out pretty boldly and against all of these EOs, but specifically he said, you know, trans people will always be protected in the state of Minnesota. How much can people like Tim Walz or Gavin Newsom or other, you know, governors and AGs in these states where they have these protections, like, what is their course of action when it comes to these bans and the federal funding being taken away?
Yeah, we're gonna find out.
Oh, you don't have all the answers?
No, but what I will say, unfortunately, is that like one of the ways that the federal government has for a long time forced states to do what it wants is by basically holding federal funding hostage until states comply with a certain directive. One famous example of this is raising the drinking age in every state to 21, right? That only happened because the federal government threatened to withhold funds. I think it was for roads specifically,
Yep.
but somebody can correct me on that if I'm wrong, right?
No, you're right, yeah.
So the federal government uses that strategy all the time. It's certainly not something that Donald Trump invented, but I do think that state attorneys general and governors have a lot of power to put pressure on big institutions like hospitals and say, hey, you're still in New York, you're still in Minnesota, you're still in California, you have to comply with our state laws. But I think the federal government might really ratchet up these strategies of withholding federal funding and start really pulling funding away from all of those states that stand up to the federal government. And so then I think it'll be a question of, well, how far then are those states willing to go to fight back, right? Are they gonna stop sending money to the IRS? You know, like I think it'll really depend on how much governors are willing to escalate that state federal power struggle. And ironically, it's going to be the quote unquote blue states that are fighting for their independence from the federal government, which is a reversal of how things have normally gone in our history.
Again, we are living in a simulation, everybody. There's no way that this is real life. Watching Elon with his kid and his kid literally telling the president, you know, I wish you weren't here, or whatever that kid said. Oh, like this can't be real life. Yeah. Well, okay. So we are almost out of time. So I want to honor everybody's time. And also, you know, again, Rage Friday, got to send people out maybe with a little bit of hope. So doing all this kind of research and kind of like tracking this trajectory and seeing the writing on the wall, what gives you hope, Garnet?
What gives me hope is that all the people, there are already people out there finding ways around these bans, and there always have been and there always will be. So especially in my work on abortion access, I do a lot of coverage on abortion funds, for example, and community support networks and all the things that they do to get abortion pills to people living in the deepest red ban states or to help people travel out of those states. A lot of those organizations have already, and I mean years ago, expanded into helping people access gender affirming care as well. For example, there's an organization called Elevated Access that has a network of volunteer pilots who fly people out of states where abortion is illegal or where gender affirming care is banned, and fly them directly in a teeny little private plane to wherever they need to go to get their medical care. So there are all kinds of people and organizations out there doing very important work who don't care about what's legal and what's not. They only care about getting people the help they need. And I think that's something that we're all just going to have to really double down on.
Right. Well, you heard it here, folks. There's pilots that are helping to transport people. There's a little bit of hope out there. There's governors who are trying to stop all this nonsense. Thank you so much, Garnet. Your presentation was incredible. You've gotten nothing but kudos in the chat here. I appreciate you taking the time to talk to us here in Arizona. Thank you so much.
Oh, well, thank you all so much for having me and for coming today.
Right on. See you next Friday, everybody. Have a great weekend. Take care and happy President's Day. Bye.
Bye.